Hello, I'm Karen Butler, Principal Researcher at the Law and Justice Foundation of New South Wales. This presentation is based on a project the Foundation undertook with Legal Aid New South Wales under our Research Alliance. However, we will look at this topic through a more inclusive lens that is more relevant to legal assistance providers broadly, not just legal aid. The publication is available on the Foundation website if you would like to read more. It's called Developing a Triage Framework, Linking Clients with Services at Legal Aid New South Wales. It was written by Christine Comarellis and Hugh MacDonald, and I'd like to acknowledge the great work they did that this presentation builds on. This presentation will briefly look at what triage is, what are some of the approaches to triage, and how you might go about developing a triage model for your service. Triage is often defined as the sorting of and allocation of treatments to patients according to a system of priorities designed to maximise the number of survivors. It is the sorting of patients according to the urgency of their need for care. The Cambridge Dictionary also defines triage as the process of examining problems in order to decide which ones are the most serious and must be dealt with first. Triage takes into account the urgency, severity, and complexity of the problem. For example, urgent legal problems might include instances where a legal process or consequence is imminent, or where a client is in crisis. Imminent legal problems may be a court appearance, deportation, mortgage default or repossession, or risk of a child being taken out of jurisdiction. The urgency is used to determine the speed of the intervention that is necessary to achieve an optimal outcome. Urgency is independent of severity and complexity. Also worth noting here is that triage is often not a one-time event. Triage is a dynamic state. If circumstances change or more information becomes available, re-triage must occur. Triage happens at all levels. System-level triage refers to triage that happens at a sector-wide level. It refers to mechanisms that direct people towards different types of legal assistance. Organisational level triage, sometimes referred to as provider level, can occur through service initiatives. For example, it is well recognised that those clients who are able to contact a legal service looking for help are fundamentally different from those who do not contact a service looking for help. In other words, how hard a legal service is to find determines the kind of clients who will find it. Service initiatives such as outreach services aim to take the service to the client, rather than the client having to find the service. This is particularly important for certain demographic groups, typically those with lower legal capability or who otherwise face barriers to accessing mainstream legal assistance services. Other examples of organisational level triage would include the allocation of greater resources to certain types of legal problems, such as crime matters over civil matters, or duty lawyer services in local or family courts to target clients based on legal problem type. Individual level triage refers to the criteria used to select or prioritise clients for assistance within a particular intake stream or service. So for some services, such as outreach or duty lawyer services, triage occurs at both the organisational and individual level. Because although these services, by their very nature and location, are already targeting certain types of client and legal problems, clients who access these services can be further triaged to match the client with the appropriate level and type of assistance. There are a variety of principles or approaches to triage that are useful, and many of these are founded on bioethics principles, but they're relevant for legal services too. The approaches chosen are often dictated by the mission or the aim of the service or organisation. Most commonly, a combination of approaches are used. Some of these approaches include first come, first served, just providing the service to those who come through the door. The risk of this approach is that it may favour potential clients that are more capable or persistent, rather than those most in need or the least capable. It is also often used for the allocation of clients within some outreach clinics. Equal chance of receiving the service, or the lottery approach. This approach is not often used outside of research settings or trials and is generally used in order to create the equivalent of a randomised trial. Weighting can be added to particular groups if necessary, and this approach can sometimes be useful when other more nuanced or just ways of triaging are impractical, or after other approaches have already been applied and there are still more equally situated claimants than resources can accommodate. Priority to the worst off in terms of legal need, assisting those likely to have the worst legal outcomes if not assisted. There is a risk that those with more may have more to lose and therefore can sometimes preference wealthier or better off clients above those who have less. So there is a need to factor in client resources and capability. This can be done by considering who has less chance of getting alternative help or a good outcome without your assistance. An example of this may be the allocation of grants or some targeted outreach services. Priority based on urgency. This is an emergency room model. This preferences those that are in urgent need at time of allocation over those who will be worse off over a lifetime. An example may be that duty lawyer services may consider urgency over severity. Best outcome or longer term outcomes. This approach is a forward-looking approach that looks at how much an individual will gain or avoid losing compared with other possible claimants. It depends both on the expected value of the outcome and how likely they are to occur. When considering longer term outcomes, age weighting will preference younger people over older people, as the intervention may have a longer effect. Impact of the outcome on young people may be greater. An example would be special provisions for young people or young people as a priority group. And then assisting the most people, allocating resources to the cause that will benefit the most people rather than to a cause that benefits only an individual. In a world of finite resources, this can sometimes be helping a large number of people a little bit or helping a few people a lot. Developing a triage model requires consideration of a number of factors and how they relate to each other. We'll outline just a few here. The aims of triage for a specific service will depend on the broad principles and goals of the organisation, as well as the more specific aims and goals of the particular service delivered. For instance, the aims, vision and purpose will guide the basis for determining its client pool, with some organisations providing services to the broader community and others providing services for more specific target groups. An example may be generalist services versus specialist services. So the triage principles chosen may depend on the organisation's mission statement, vision, strategic framework priorities, legislative mandate and scope, governance board, or funding requirements. The type and role of triage will also vary by intake mode or pathway. For example, legal advice telephone lines, legal advice clinics, outreach clinics, and duty lawyer services are likely to vary in terms of the mix of clients and their legal capability, urgency of issues, and type of need. Some intake pathways may be open to the broad community, like telephone advice lines, while others will be only open to a specific target group. Organisations may decide that those with higher legal capability should perhaps be filtered out or linked with external assistance. Triage may vary according to client characteristics. Specific disadvantaged groups can be targeted by service initiatives, such as people experiencing homelessness, prisoners or migrants. These client groups can face particular types of complex problems and may experience heightened forms of disadvantage. Legal capability of clients refers to the personal characteristics or competencies that are needed to effectively resolve legal problems. These competencies might include knowledge, skills, psychological readiness, and other resources. A relevant triage question would therefore be, how likely is this person to be able to resolve the problem without assistance or without assistance to a certain level? To answer this question, it can be useful to know how long this person has had the problem. Relevant criteria for triage may also vary by area of law, criminal, civil or family, and type of action, litigation compared to transactional legal services. Some areas or actions have greater potential than others for self-help or unbundled service provisions. Legal assistance services are often targeted to different types of legal problems. A relevant triage question may be, is the presenting legal problem one for which the service can provide assistance? How much assistance is required to progress or resolve the problem? Does the service have the capacity to provide assistance in the given circumstances? Remembering legal problems will also vary according to their urgency and severity, and these are key criteria for triage. Knowing what other services are available is fundamental. The general purpose of triage is to link clients with relevant services. Triage questions here concern what type of assistance is appropriate and whether there is capacity to deliver that assistance. For instance, can the triage officer assist directly with the presenting problem, especially if triage is undertaken by a lawyer? Is another service provider more appropriate? Available service options will vary by the capacity of the service providing the timing and urgency of the issues, the geographic location of the client, and the capability of the client to make effective use of a particular service or assistance option. If the legal service provider cannot assist with the problem, then the client will have to be triaged out irrespective of their legal need or capability. And this is where it is important to keep up to date with what other services can provide. Another key question is who will get the most out of the assistance provided? This is where we consider the difference between clients in terms of the potential impact of any assistance provided. It's important to say here that triage on the basis of likely outcomes requires the ability to predict or at least anticipate the future outcome with and without the available assistance. This will depend on appropriate and comprehensive information being provided at intake and the triage officer being able to effectively apply this information in the client's particular situation and circumstances. This will require the triage officer to have a high level of legal skills. Depending upon the pathway and purpose of the triage model, triage may be undertaken by a legal services officer, a generalist lawyer, a specialist lawyer, or a referring non-legal worker. The capacity to assist at the time of triage will depend upon the match between the skills and the capacity and the role of the triage officer and legal issues, and possibly also the client capability. Automated triage or online triage is an area that is seeing some development, and we will be keeping our eye on that. The value of discretion in a triage model cannot be underestimated, so it will be interesting to see how automated triage accounts for that. So what might triage look like? Some states seem to be moving towards a centralised triage model, where clients call a central information or legal helpline. But even in that context, triage is also done at organisation or service level too. Subjecting all clients to the same assessment process can be an equitable and just approach where demand outstrips supply. An organised client processing system that allows for easy flow of client information is essential, as is being aware of appropriate referral channels, including onward referral, and the data on availability of services. To summarise once more, Triage is used to identify and link target clients with services appropriate to their legal need and capability. It is used to direct limited resources to those most in need or for whom the assistance provides the most benefit, and it can also be used to guide or refer non-target clients to other forms of assistance, such as self-help or other legal services. As we saw on a previous slide, the intake pathway determines who will have contact with the service, so some clients will already be filtered or triaged out. And onward referral pathways, such as self-help or other legal services, will filter out more clients. Triage tools are the questions that we ask to filter or triage clients, and they will be specific to the triage model that you use. Effective triage depends on linking clients with appropriate services. So knowing what works, for whom, in which circumstances, is crucial. The Foundation has done considerable work in this area, and there are several papers on our website that examine this very question. To do this, we undertake systematic reviews of evidence to identify what is currently known about what is effective in assisting people to meet their legal needs, and conducting evaluations of new projects aimed at assisting people to access the justice system in order to learn new lessons. Please visit our website to learn more. Now, the very last slide is just a brief mention of a very important part of any model development, and that is monitoring and evaluation. The purpose of monitoring and evaluation is to learn from your experience to improve practices and activities in the future. Monitoring and evaluation does not have to be a complex or complicated process, but it is invaluable for identifying barriers and facilitators, which approaches work and don't work, and why. The benefit for the sector is that we can learn from each other. The Foundation is continuing to work in this space, and we endeavour to share all our learnings. So sign up for our research alerts to keep up to date with what we've been doing. So we hope this presentation has been helpful, and would like to invite you to subscribe to our research alerts or our newsletters, Justice Access Research Alert, JARA Focus and Plain Language Law. Thank you for listening.